Oh, wait, meeting's not being recorded, so it's recorded.
Christie, are you trying to move out of the vision?
Done is. Yeah, it's just the light right there.
It's not ideal.
Oh, there we go. That's helpful.
Yeah, that's like backward too. That's
It makes the flag look pretty,
exactly.
Yeah,
beautiful.
that's better. Yeah. Well, we have to, so we'll call the meeting to order at, 6.
6 o'clock.
6 o'clock. So this is our first meeting, official meeting of the appeals board in over 5 years, so we're all new to this board. So we need to choose a chair and a secretary before we can proceed. So,
I nominate Christie as a chair. Because of your previous experience on the appeals board.
sounds good to me.
So. There's a motion and a second.
Yes, I second that.
Do you object?
No, as long as you're, bear with me as I navigate it, I know that. So, that's fine.
Wanna vote?
So do we vote?
Yeah.
All in favor?
Aye.
Okay.
We really have to do that.
Yes. We do. So now we need a secretary. To take note for the meeting, so. Either one of you two.
I'll nominate you.
Alright, well, I'll second that nomination, so, all in favor, Michelle, being secretary? Okay. Alright. So we are here to determine, or to evaluate the appeal of the solar ordinance by the, for the application that was put into the, can't even speak.
Canelo
Yes, thank you.
or Barrett Energy Resources Group.
Yes.
See,
Okay.
So the representative is here tonight and you wanted to give us a little bit of information about the project before we get started?
have a PowerPoint if that would be useful.
Okay.
So I have it on the thumb drive. Is that easy to?
Yeah.
I think we should do executive session.
You wanna do it in second? Session first? Okay.
Okay.
Sure, that's fine.
Yeah.
So
And then we
we'll-
can watch, yeah.
So you want us to?
So we're gonna make a motion to go into executive session for consultation with the lawyer per MRSA, section 405(6)(e).
Okay.
We have a,
Oh, I'll make a motion. I'll make a motion to go into executive session under the,
MRSA 405(6)(e),
yes, that.
and I'll second. All in favor? Okay, so we're gonna move into executive session.
Enjoy the sunshine.
Welcome back. Okay, so, I guess we'll start off, with making sure that we have a quorum, which we do. So, we're going to, I make a motion that the board has a quorum. And
I'll second that.
forward, a second, all in favor? So the next issue we want to address is to make sure there's no conflict of interest. So such as, are there any members of the board aware of any direct or indirect personal or financial interest in the subject matter of the application? I do not.
Nope.
No, okay. And then is the applicant or any other person aware of any personal or financial interest of a board member in the subject matter of the application?
Not aware of it.
Okay. So that being said, we need a motion to find the members of the board do not have any direct or indirect personal or financial interest in subject matter.
I'll make a motion that the members of the board do not have a direct or indirect personal or financial interest in the subject matter of the application.
I'll second that.
All in favor? All right, so now we are to the type of application and determining what type of application it is before we're actually moving forward with the process of the appeals board. So we need to determine if this is a variance request or an actual appeal to the planning board and how the process occurred. I believe, is that correct? Okay. So it looks like it's an application for an appeal, so we would record all of the information, or review all the information that we have to this point.
Well, are you appealing a decision or are you going for a variance for the ordinance?
Requested a variance.
You're requesting a variance.
We did submit information that we intended that the ordinance allows for our project. But the planning board determined that it wasn't, they didn't agree with our argument on that matter. So I wrote, it could be both.
What you would characterize, so. You're intending to put on evidence tonight about why you think you're entitled to a variance of the ordinance, is that?
Yeah.
So I think I would advise the board, this is more like a request for variance. Than a straight appeal.
So, the next question, if that is the case, would be if we, as an appeal board, have the actual jurisdiction, excuse me, to make that variance, basically, determination, if that's what our goal is. So we would need to review what the ordinance. Or do we need to listen to the application?
Yeah, so I think it's appropriate to question the applicant, if. And have you identified any like legal authority for the board to grant to grant a variance to the solar ordinance?
No, we've just been, following the advice of the board. We're familiar with the solar ordinance.
Yeah.
So that was specifically the process that was developed by the town to review solar projects. So we reviewed that, we submitted our application, and then we kind of identified this one piece that determined whether we were certain size project where there was some different information. When we realized, that's when we submitted the application for variance. However, beyond that, we sought advice from the planning board and the board of selectmen as to what the next step was, and the board of selectmen determined that we had to go to a board of appeals, which had not been formed yet, but they would encourage that it be formed and a staff member. That's why we're here tonight. And they acted very expeditiously, which we appreciate.
So I guess the reason I asked, that under Maine law, a Board of Appeals can't act unless it has like very specific authority from in the ordinance to either grant a variance or hear an appeal, and in reviewing the town's solar ordinance, I didn't see anything that would indicate that it has that authority. I think the Board of Appeals has authority to grant variances to other ordinances. And to hear appeals in other situations, but I don't see anything in the solar ordinance that would give it that authority, and certainly I've been able to look something, and I don't want to, I don't want to prejudice your application in any way. I don't see anything that would give the board authority to act on a variance application for the solar energy ordinance.
If the solar ordinance is a part of the larger zoning ordinance.
Yeah.
And it's silent on, because there are other parts of the zoning ordinance which might not have their own specific. Appeals process, wouldn't it just defer to an appeals process within the larger zoning ordinance?
Yeah, so the town has a shoreline zoning ordinance, right, and it has a minimum lot size ordinance, am I remembering that correctly?
Yes.
I don't know if it has a zoning ordinance or not, though.
Not.
Yeah, so, and you're right, you know, if this were a true zoning ordinance, I think that there would be a stronger argument that there could be some sort of variance because there's state law on allowing variances to zoning ordinances, but I don't think that this is a zoning ordinance. So that's, I think my advice to the board at this time is that I don't think the board has jurisdiction to hear a variance or an appeal on this matter.
That's, I'm sorry, does precedent matter because the Board of Appeals has been formed for, and I don't know if that was related to the matter which doesn't necessarily.
Yeah.
In the ordinance.
Yeah, I think you've served on the Board of Appeals before. Do you want to
Correct.
speak to that?
I guess I don't understand the question, can you?
Well, I understand that the Board of Appeals was formed 5 years ago to address the matter. And I was just wondering if that was under the shoreline zoning or if it was some other matter that might not have a specific appeals process.
So I almost think I don't remember the exact date of the last appeals board. I know it was disbanded, all members at that point, after a couple of years, just because there hadn't been any appeals. So, we did do, a shoreline zoning, and then, I can't remember what the other one is. I'd have to refresh my memory. So, but yeah.
That appeals board was called to address a request for variance under housing minimum lot size ordinance specifically. That is it.
Yeah, and the housing minimum lot size ordinance has specific provisions that speak about how to grant variances and that sort of thing. But that would authorize a variance to that ordinance.
Okay, what about if we go back to the point where it could be a request for a variance or it could be an appeal? Even with appeal, there's no mechanism for
I similarly didn't see anything that would authorize an appeal. There is a general planning board ordinance, but that doesn't specifically say that there's an appeal to be taken to the Board of Appeals, as far as I saw. But again, if somebody's more familiar with the ordinance and can correct me, happy to be wrong.
Not that I'm aware of.
Do you guys have any input on that? Or that it would be different?
Yeah, I don't see anything in this ordinance that says that there's generally an appeal from the planning board. I think there's an appeal under shoreline zoning and that sort of thing, but not just a general right of appeal from the planning board.
There is for shoreline zoning, there is for minimum house lot size.
Yeah.
Number of other ordinances happen also,
Yeah,
but not so.
no, not the solar ordinance. I read through that like 3 times.
Folks. I may, we already got the question.
Yes, go ahead, Dan.
So the planning board brought it before the select board for conversation. The select board immediately said, if you want, we're not gonna touch it, we're gonna call, we're gonna convene an appeals board. So if the appeals board actually has no standing, does this simply come back to the planning board for reconsideration?
Did the planning board deny your application, or did they make a vote of denial, or did they?
I don't think so. I thought that they just recommended it.
No, we denied it.
Okay, you didn't vote.
Because,
Because there was
because there were some things that needed to be looked at after the first meeting. That's the reason, but it was more of, can you look at these areas and see what we can do? That was from the second meeting. But we denied the application there. That's why it went to the select board.
Yeah, I think we denied the application due to the fact that it didn't meet the nameplate requirements of
Just because it didn't meet the nameplate, but then we, putting the,
On 2.4, a motion to deny the application as the nameplate capacity is higher than the current ordinance allows. Technically, this qualifies as a large installation. Don second and the motion passed.
So I have a question about that. Because in our ordinance, it says for medium scale. The nameplate capacity of up to but not including 1 megawatt. But you don't specify if we're talking AC or DC.
It does it in definition, I believe.
Yeah, that's definitions.
So where is that?
At the beginning of the ordinance, it has all the definitions listed out.
The second page, cause I looked for that.
Yeah, rated nameplate capacity, is that the definition you're looking for?
Page 2, about 3/4 of the way down, rated nameplate capacity, maximum rated output. Electrical power production of the
So
photovoltaic
it says-
system in watts,
Okay,
direct current DC.
I don't know if I can ask you as legal representative to the town this question, but it might still be a question that's affecting the decision is the definition of the medium scale project has two criteria. One, the size of land disturbance of 6 acres, and then the nameplate of 1 megawatt DC. And it says and or, and so the planning board determined that and or means you have to meet both definitions.
The planning board did not determine that. That has not been determined.
Okay,
Because you presented that argument after the select board already said they were gonna convene the appeals board.
okay,
So they said we could not reconsider because the appeals board process was already underway.
okay,
if you, in the and or. Size wise, he's under the 6 acres.
Correct.
He's
Yeah.
under
One or
that.
the other, but there's no clarity on the, so it's and or, so I mean, it's a very gray.
I guess my argument was that because it said and or, the board could choose and thereby we wouldn't meet it. Or they could choose or, so either one. So I guess, I would like the opportunity to present why I think it should be or. And primarily it's because of land disturbance.
Yeah.
The 1 megawatt capacity really doesn't mean much to anyone, but the 6 acres, people can kind of understand that relative to the purpose of the ordinance, which is, public health and safety and damage to the environment and consistency with comp plan, and 2 other things I can't remember, but basically the area of impact is how you evaluate those things.
Yeah.
So anyway, so we would like the opportunity to be able to present that to someone.
Yeah, I don't think we're the appropriate people
Doesn't
to,
sound-
yeah, according to our ordinance, the way that it's written.
Yeah.
So I think there's a we're having discussion now about whether the board has jurisdiction. I don't know if. When I get a motion or if there's further comment on that.
I mean, I'd like to make a motion that we do not have jurisdiction based on the way that the ordinance is written.
Wait a second.
I'll second that. See how enthusiastic I am about that.
Any discussion, any further discussion?
I mean, I think it's unfortunate that we cannot, that we don't have jurisdiction. That's all I want to say for discussion.
Motion second, all those in favor? We do not have jurisdiction. So do you want to speak on the and or?
So at this point, though, if the board doesn't have jurisdiction, it has to deny the application.
Okay.
So that would be another vote. And then if you want, you can adopt written findings tonight, because the findings have to be in writing. But the first thing would be to vote to deny the application.
I make a motion to deny the application for a variance.
I'll second that.
Can you add to that, understanding, under the idea that we have no stand?
Yeah, because we don't have any jurisdiction to grant the variance as the ordinance is written.
Can I, but is that really denying, or just we won't even consider it because we have no jurisdiction?
Yeah, I think it operates as a denial.
Yeah,
Of the application to
I
this.
just feel like an actual written denial is different than saying we can't take it under consideration because we have no.
Yeah, we can't even vote on it.
So you can vote that you don't, as you did, you voted that you don't have jurisdiction. Because you don't have jurisdiction, you have to deny, and that decision has to be in writing. The decision to deny and the reasons why you denied, because you don't have jurisdiction.
So on the floor, we have a motion.
motion.
I'll second.
Any further discussion? All those in favor denying the application, how do we word that?
Deny the
Denying the
application because we don't have jurisdiction.
They don't have jurisdiction to consider
To
it.
consider it,
Sorry.
so. All right, all those in favor,
So, is that-
so moved.
so what happens now?
Yeah, that's sort of up to the applicant and up to the. There was an application for an appeal or for a variance to this board. I'm not aware of what the status of the application for the planning board is, and I don't think it's appropriate for this board to weigh in on that, or for me advising this board to weigh in on that. But. Yeah, the denial operates on the application for the variance. This broader status of the application is kind of outside the scope.
So do you need to put in writing before we adjourn,
I have
obviously?
Draft written findings, if you want to consider those, and I can hand some up for the.
Mhm,
For
sure.
independence as
Take
well.
that into consideration.
Yes, I would love to take that into consideration.
Someone.
He's being recorded, could you guys, before I'll just state your
Thank
name,
you.
like who you are for the record, because right now there's no register.
Oh, Michelle Larrabee?
Christy Carrier.
Jamie Harding.
I think this is pretty straight to the point.
Yeah.
What we just did. So if I need to, I'll make a motion that we use this draft.
I'll second that.
All right, so we have a motion and a second. Do we have any further discussion?
Mm-mm.
So, we will take a vote, all in favor. Motion carries. As signed and date, let's do you,
I think we were pre-filling one out.
Let's confirm that. Jane, how do I spell your first name?
J-I,
J-A-N-I, just like it sounds. We should actually do a copy for the applicant as well. Yeah.
yeah.
Are you handwriting another one?
Yeah.
For that, okay, because I'm like, I don't think I can get in there to make a copy.
I have a bunch of these, so we can.
Oh, okay.
Wrong. Someone else have a copy.
I'll try to make a copy with the
Oh,
copy.
gotcha. Just want to steal them off of your desk.
I'm happy to help you with that, John. So that is Paul.
Yes, I'm sure, and I'm getting stuck over here. Got tangled up in the cord.
Sure. Would you want to put it in your notes with your public attendance? We just in case.
I have like chicken scratch over here. I was gonna go home, watch the meeting and really take my notes.
It's just another copy.
Looking for people for the copy.
You need to understand.
What's your last name?
Ever like EVERY. Yeah.
I should have known that.
That's not in the same spot.
Hang on, Michelle.
Oh.
All right, so, that's done, so. At this point, we can entertain a motion to adjourn.
I'll make a motion to adjourn.
I'll second that.
Motion, all in favor?
How many copies do you want?
We do.
Motion, or meeting adjourned.
Yeah.